Welcome to our continuing YouTube video series on wills and estate planning. My name's Christopher Neufeld of Neufeld Legal, and in this particular video, we'll look at the question as to why you also need a power of attorney and personal directive in your estate plan. Now, a lot of people go into their estate planning meetings with lawyers or even looking at it conceptually without engaging a lawyer, and that all they do is put together a last will and testament. But they come across, whether it's on the internet or referred to by the lawyer or the lawyer's assistant, that they should also have what's called a power of attorney. And they question, why do I need more documents? I just want to get a will done. Well, the reality is that a will is only designed to deal with the disposition of your estate and your related affairs after your death. It is not designed to deal with matters preceding your death, which can be, and in many respects for you personally, far more important. So, what happens if you become incapacitated? You get in a car accident. You just become too old. You get dementia. Your spouse is no longer around. For whatever reason, your kids are not available. But even if your kids are available, what happens? Who takes charge of your finances? Who takes charge of your healthcare decisions? Now, if you don't have a power of attorney for finances and a personal directive for health, you're really going to have to rely upon the largesse of the court. And that of itself is time-consuming, costly, and potentially problematic. What would be far preferable is when you have your capacities, your wits about you, to actually take charge of your own personal disposition and determine who is most appropriate to oversee your financial matters should you become capacitated. 1, 2, 3 people in that order. Similarly, if you become incapacitated, who should be overseeing your health decisions? And on top of that, what are the conditions that you want to instruct the person on, basic terms as to the financial matters? What are you looking at with respect to how they should oversee your finances? Similarly, what are the basic tenets with respect to your health? If you become incapacitated and unable to make your own decisions for yourself. This is the time before you become incapacitated that you make those determinations. And you got to make those determinations with your full conscience to it and set it down in paper and have it properly drafted and executed so that it is a binding legal document that parties can look to actually protect you, protect your finances, protect your health, and make the decisions in accordance with your pre-existing decisions. So that is why you really need to consider having a power of attorney, personal directive, both with respect to your finances and property and with respect to your health, as well as having a last will and testament. I hope this video has provided some elucidation with respect to these additional legal documents, which are extremely important in your estate planning matters. And these are matters which we strongly recommend you engage legal counsel for. As myself, a lawyer practicing, thank you very much, and we look forward to talking to you again.